Let's follow up now, sort of on this issue of testing, of chemical tests. When I watch TV and courtroom dramas, a lot of times you'll see somebody talking about the results of a test, and somebody will jump up and say, "I object." And somebody else will say, "Well, I have a motion to suppress," whatever that is. So I want you to educate me a little bit. How is a motion to suppress different from an objection during a trial?
Well, that's an excellent question, and it's actually a gray area of the law that is getting a lot of attention. Technically, a motion to suppress is something that is done pre-trial before the jury is ever called in or the trial begins. If we have a good faith belief that some procedure wasn't followed correctly, we will file a motion to suppress. In a breath testing situation, let me just take an example. You get down into the breathalyzer room and you're told that you have 30 minutes to get a witness present, and you make a phone call and you can't reach anybody, and so you sort of close down your cell phone and they say, "Well, you ready to take the test? Why don't we go ahead and get it done?" Well, they didn't wait the full 30 minutes to allow you an opportunity for that person to call back. So I have what I call the 30-minute suppression rule because they haven't followed the statute.
Right.
Well, before the trial ever begins, I'm going to file a motion to suppress and try to get a judge to rule that that breath test never comes in because the state didn't follow the right procedures. That's different than if in the middle of trial they call the breathalyzer operator and the state is asking the breathalyzer operator these questions, and I object for what's called lack of foundation. That the state didn't lay the proper foundation that the breath test can come into evidence. So objections are different than motions to suppress, but ultimately they're going to try to accomplish the same goals.
Well, what are some other ways in which you can suppress a chemical test?
Well, breath testing is regulated by North Carolina General Statute 20-139.1. There are set procedures on how a chemical analyst is able to get evidence evidence during a trial and ways that it must be preserved. Specifically, you have to be advised properly both orally and given a written copy of your breath testing rights before they can ask you to blow. And if that procedure wasn't followed correctly, you can get the case, get the evidence suppressed. With regard to allowing a witness to come back during this 30-minute observation period, if you had a witness arrive and that witness wasn't let back, you may be able to get the breath testing suppressed. If the procedures weren't followed to the letter of the law on how the machine was set up, on the observation period, things that can affect the accuracy of the test, that could cause it to get suppressed. If you weren't given a proper 30-minute period after you've exercised your right to get a witness present, that could get it suppressed. If you had obstructions in your mouth, dentures, mouth alcohol issues, that could get it suppressed. There's a huge long list of statutory violations.
Once again, reason enough to contact the Dummit Law Firm. There's so many of these issues that you need to be advised of. And we have another one coming up we're going to delve into in depth on the next segment. We'll talk about blood tests.